Welcome back to the study in the old rectory at Epworth. My name is Guy Lewis and today I'll be presenting session 2 of 3 on general data protection regulation. So on this second session we're going to look at your obligations under GDPR. We'll look at privacy notices, basic principles, rights, contracts and consent and data breaches. So when you are collecting personal data under the Data Protection Act, you must give the individual your identity and you must explain how you intend to use their information. Under GDPR, you also need to include your lawful basis for processing this data and data retention periods and that the individual has the right to complain. GDPR requires that the information you need to provide is concise and easy to understand and in clear language. How do you communicate your privacy policies? Well, you can do it verbally in a telephone conversation or face-to-face, but you must document that conversation. You can do it on the website, so you can actually have your privacy policies actually in your website. You can do it through email with a link to a website or a document within that email, or you could do it as a printed document and ask people to sign it in your presence. A typical privacy notice might contain information about marketing updates, about information about up and coming events, and all sorts of other activities of the company. So you must actually specify this in your notice, and also that they have an option to opt out of that and not continually receive this information. Typically we can do that through a post on your website, through an email, but you can also get apps that do allow you to look at all the relevant parts of your privacy policy and possibly agree it as a function. The GDPR balance is something I talk about quite a lot, and it's the balance the right of the data subject against the legitimate business interests of the business. So I have this balance here where I started saying in session 1 that actually we are all data subjects. We are, individually, if we're outside of business, we're a data subject. And GDPR tries to make a balance between what a business needs to do in terms of giving you information, in terms of sending you emails, in terms of communicating with you, and actually what your rights are, and actually have them rights been infringed or impeded. And what I always think about in this balance is if I was being emailed something that I was interested in by a business, is that right? Or if I was just being emailed stuff that I'm completely not interested in and I can't stop them doing it, is that right? And somewhere in the middle, there is this GDPR balance of actually that's information about something that I do, and the business may know that because I've already bought from them or I've bought from one of their partners, against something that I'm completely not interested in, and please stop. The fundamental data protection principles are to ensure that the data you keep is in line with the GDPR regulation. So it's fair, lawful and transparent. So you're keeping that the data is legal and that you are letting people know that you're keeping that information. And fairness actually goes back to my first session where you're looking at if you were the client, if you were the data subject, do you think it's fair that someone's keeping this data on you for whatever reason? You must actually be very explicit in what data you're keeping, and you must limit it to what you require, and that must be for a legitimate purpose. The data must be minimized. I actually only keep the data you need, limit it to what you really require. If you don't require email addresses, then don't keep them. And you must take all reasonable steps to ensure their ongoing accuracy. With data, you must keep it only so long as is necessary, and you must make sure that data is kept securely. Within GDPR, there is a list of individuals' rights, and these include the right to be informed. I need to be informed that you're keeping their data, the right to access that data, a right to make sure that data is correct and rectified, the right to have it erased, the right to restrict processing so that data cannot be used or manipulated, the right to object, and the right to not be subject to automated decision making, including profiling, which is usually used in the financial sector. So the right to object is individuals have that. They can reject on lots and lots of different things. They can reject on legitimate reasons about processing. I don't think it's a reasonable reason why you've got my data and why we're processing it. And I can also say that I don't want I'm objecting to my data being used for public interest. You can also object to having direct marketing, including profiling. And you can object for having your data processed for scientific or historical research. So one of the things we want to look at now is a subject access request. put that in simple language, that is somebody who actually, a client as one of your customers, actually that is a person, a subject access request. It's a person who says, I want to know about all the information you hold of me. So what you need to do is put in place a procedure that can handle that request. There are time limits of when you get a request. So if you're holding data and that person requests to know all the data you're holding, you must reply within 40 days. And you cannot charge for that time it takes you to put that data together. You can, however, refuse to charge or refuse the request if it's manifestly unfounded or excessive. So that actually is trying to catch people that maybe are for some reason asking for a subject data request every week or every month. So you are allowed to sort of say, actually, I gave you all my data last month. I'm actually saying, no, I'm not going to do this. But if you do refuse, you must keep a record that you have done that. So when you do respond to a request, you get a request from one of your clients, someone who's stayed with you, someone who's bought something with you. The first thing you must do when responding to that request is identify that that person is the real thing. So you need to verify the identity of the person making the request. I suggest you do this through a number of routes. If you've got phone numbers, you phone them. If you've got emails, you email them. If you've got an address, you also send them something to the post. And only when them three line up do you continue responding to that request, because a data breach of giving someone else's information to not that person is a data breach. So what you must do, you must provide a copy of the information free of charge, and you must do it either as a hard copy electronically or via some sort of electronic self-serve portal, and you must provide it within a month of receipt of that request. So I just want to talk now about that lawful basis of processing. How can a business actually lawfully process information about an individual? And usually, and most common in all areas, is through contract. Through a contract. You have a contract that means you can lawfully process some data. So if someone actually books a room to stay in your hotel, that's a contract. If somebody actually signs up to a mail order of coffee, that's a contract. If someone actually buys a cup of coffee in your bar, that's a contract. There are other things around things like legal obligation and vital interest that are probably not really relevant to this sector. They're more about government sectors or around health. The only other one to look at, apart from contract, would be consent. So consent, I mean, GDPR sets out a really high standard for consent. I think in the past, businesses have sort of said, I have consent when they can't prove it, whereas now they're looking for a sort of real high standard of that. So consent means offering the individuals a real choice. So a genuine consent should put individuals in charge, and it should be fair. It should start to build that customer trust, and it should enhance your reputation. So what you should do now is to check your consent practices, both with new and existing clients, and maybe need to refresh them if you've not had contact before the GDPR period started. So that consent requires a positive opt-in. So that requires me, yes, I do consent. You can't actually get consent by a negative opt-in. It has to be tick this box if you opt in. You can't use an unticked box or a pre-ticked box. So it has to be very, very clear that it's a positive opt-in. It also has to be, make sure that that opt-in isn't actually explicit on actually getting the product. You know, you must actually opt in, give consent to marketing, or I'm not going to provide you this information, or I'm not going to sell you this product, or whatever that contract relationship is. So when you are asking for consent, you must keep your consent requests separate from the other terms and conditions and other options. You must be very specific and granular so that it's very separate and it's very identifiable, and it can't be vague and it can't be a blanket. So it must be very specific. It must be clear and concise. It must name any third-party controllers who also will rely on that consent, and you must make it easy for people to withdraw that consent. So while they may consent it once, they may find that they don't want to do it again, and they must tell them how they can withdraw their consent. You must keep evidence of that consent. Even if it's verbal, you must document it. You know, how you got it, when you got it, with who you got it, etc. And also you must keep your consent under review and refresh it whenever you think it needs updating. Avoid making consent a precursor to any other service. Data breaches are a requirement that all organisations must report personal data breaches, and they must do that within 72 hours. If it's likely to result in a high risk of affecting the individual, then you must also involve the individuals. There is a question about what is a high risk of adversely affecting the individual's rights, but actually as a good business, you would expect, if you go back to your risk register, that as part of that, that risk of financial and operational reputation, that if you've had a data breach and if you've given out inadvertently people's sort of names or personal details, that you would get in touch and say, we've had a data breach, this is what it was, and this is what we've done to lessen the impact of that. You must ensure you have some form of robust breach detection, which actually means having really an open relationship with your employees, and also being very careful yourself that actually what you're doing is accurate. If you're sending emails, you're checking who you're sending it to, that you're making sure that that you're doing the best you can to make sure you don't have a data breach. And then you must also then keep a record. Even if it's an insignificant data breach, you must keep a record yourself if you are not required to notify anybody. So this is the end of session 2 of 3 on GDPR. I hope you found the session interesting and useful.